Good afternoon and welcome to the House Environment and Energy Committee. This afternoon, we're going to continue taking testimony on H.687 and we welcome Chris Campany.
Thanks. My name is Chris Campany, Executive Director, Wyndham Regional Commission. I believe I was asked to come and comment on tiers 2 and 3. And so I'll be offering comments on behalf of the Vermont Association of Planning and Development Agencies Government Relations Committee. And my comments are very focused. I want to start by saying thanks again for your leadership and taking on this very complex bill and your deliberations on it and bringing in a lot of witnesses. First, regarding Section 2010 VSA 6086A 8B, forest blocks and connecting habitat. One of the things that jumped out at me was kind of the continuum of what somebody doing a development needs to do under those provisions to avoid fragmentation of forest blocks or connecting habitat. And first is the development or subdivision will avoid fragmentation through design or location or both. 2, if it's not feasible to avoid fragmentation of the design of the development or subdivision fragmentation, or it is not feasible to avoid fragmentation of the forest block, and the applicant will mitigate in accordance with Section 6904. And in my reading of it, and this is based on prior experience, doing permitting and reviewing site plans and doing a review, that could be read somewhat as saying, ultimately, you can fragment a forest block or habitat if you've got the money or other resources to do the mitigation. And I'm guessing that the mitigation language may be existing as kind of a safety valve against a taking. And so my suggestion would be, and it references in accordance with Section 6094. I know that doesn't exist yet. I think it's 6093 is the ag land mitigation. So I was assuming that ultimately mitigation language would be created for forest blocks and habitat and connecting habitat. But what you might want to consider is laying out exactly when mitigation is allowed. And that could be something like if it would preclude the development of a home, or it would preclude all economic use. So in other words, set a trigger, not just to say you can mitigate, but when you can mitigate and under what circumstances. And I would dig a little deeper, because otherwise, and again, I would, Ledge Council and others should ponder this based on case law and other things, but just making sure that you're basically not saying, depending on what your intent is, if your goal really is to avoid forest block fragmentation and habitat fragmentation, establish very clear criteria for when that's allowed at all. If that makes sense?
Because I think we've contemplated that being in the rulemaking piece of this.
Okay.
But it does, and if you have thoughts on that language that you think either would help with rulemaking or that would be ready to go into statute, we welcome that.
Can I ask a question?
Yeah.
And so is the intent to create, so unless I just somehow missed it, I didn't see the 6094, the 6093 exists, that's the rules for ag land or ag soils mitigation. Is the intent to create a mitigation section related to forest blocks and habitat, or did I just miss it somehow? I'm not trying to put you on the spot.
I have to go look at 6094. This came from previously passed language.
Yeah.
Question.
Okay. I just want to make sure, because I don't want to lead you astray. If it existed, then I just somehow was missing that language.
The hope would be we rarely get there. The question is how.
Yeah. All righty. Then under resource mapping, and I don't know if my colleagues have already testified to this, when it comes to our regional energy plans, they're very specific. Under Act 174, it required the establishment of energy planning standards, and it required us to to map known constraints. And if you have my comments before you, then this is straight out of the, and known constraints in parens, signals likely, though not absolute, unsuitability for development based on statewide or local regulations or designated critical resources to include vernal pools from Vermont Center for Eco Studies, DEC river corridors, FEMA floodways, state significant natural communities, rare, threatened, and endangered species, natural wilderness areas, class 1 and class 2 wetlands, and then regionally or locally identified critical resources, and this is in italics, if areas are constrained for the development of renewable energy due to the desire to protect a locally designated critical resource, whether a natural resource or a community identified resource, then the land use policies applicable to other forms of development in this area must be similarly restrictive. For this category, policies must prohibit all permanent development and should be listed in the notes column. These areas should be subtracted from raw renewable energy resource potential maps to form secondary resource maps. So what we'd like to do is avoid a situation where for one required plan, the regional energy plans, we're having to do one set of maps. And then for land use maps, for future land use maps, we have other criteria to follow. And it could be use this that you've already defined. And that could be the direction we follow, but we're just looking for some kind of guidance there so that we're applying the same thing, the same thinking, because if you recall, under the standard under Act 174 is not to preclude a renewable energy development where you would allow other types of development, right? And so this could be a fairly elegant fix to and something you've already passed into statute and that we're already doing. And that's the basis also, I'll just as a reminder, not only for regional energy plans, but that also then stands as the basis for the enhanced town energy, municipal energy plans.
And that's really a great example to share with us, and I appreciate it. Can you talk about how that process is going, how it works, and then give us an assessment of how you feel like it's worked out in your community?
For us, and I have a colleague, Charlie Baker from Chittenden County, he can speak to this too if you're wanting to. I thought it worked out pretty well. You know, we worked with the state on the data sets that they had available. Our GIS people worked together and understand, like pulling together kind of standard criteria. And if I can ask Charlie, I think like even standard colors and other things, just so basically the maps looked very similar to what we're talking about to the future land use maps. So I think that process worked pretty well. The challenge, and what we're going to need to do as we update those regional energy plans, I'm just talking about those in isolation right now, we'll need to keep, revisiting what other updates have occurred to those state maps. And I think that's what we would envision doing under the future land use maps too, is, in my experience, typically when everybody's operating off the same set of maps, it's recognized that they're not necessarily static, that you're going to constantly have new information and they'll be updated and they'll assume that same official standing as they get updated over time. And then all other maps that derive from those data sets get updated. So, but is that what were you asking specifically about the maps or the regional energy plan process in general?
A little bit. I'd like to know a little about the process and how because we've been talking in this committee about how to map these areas, and it's already happening. So tell us how it's happening.
Yes, I think it works well. Where we struggle a bit is on the regionally or locally identified critical resource areas, because we really don't have any funding to do that. For a time, we had some nonprofit funding to do that through the High Meadows Fund, but it's really to do natural resource planning like that takes it's a long running and ongoing process, and you're working with local conservation commissions for that local knowledge and land trusts and federal and state agencies. And they're also, as the policy notes, community identified resource, and those would be not necessarily natural resources, but other cultural, historical, other things. And so, right, that's a constantly evolving process. And so we had worked with Jens Hilke with Agency of Natural Resources on the development of an America the Beautiful proposal that would fund a full-time natural resource planner for each RPC for 3 years. America the Beautiful Fund is through the U.S. Forest Service, and it's federal funding. But the state felt they just didn't have the capacity to manage another large grant. But we all, I believe, all the RPCs will recognize that that's a area where we just don't have sustained capacity like we do, say, with transportation or emergency planning. And this would need to be something that be ongoing, not like a 12-month or 18-month initiative. So I would say this works well with the kind of higher level state databases, but then the ability to really drill down. And then I participate in, I'm active in the Vermont Staying Connected Initiative discussions and the binational conversations around that. Also active like in the Berkshire to the Greens initiative down in Massachusetts. I'm on the Friends of Conti National Wildlife Refuge. And the reason why I bring all this up is there are a lot of conversations out there where we really need to be at the table to talk about what's in the regional plans, what should be in the regional plans, representing those regional interests, representing what our towns are saying. And so there are a lot of areas where that, beyond just our future land use maps and other things, there's the actual implementation thereof, right, through both regulatory and non-regulatory purposes. And in my experience, this isn't just a Vermont thing, this is a New England thing. 99% of the time, the regional planning commissions are not at the table because we don't have the funding to actually send somebody to them. And I participate as an executive director because, frankly, I charge it to what's called our indirect rate. I just build it into our cost of doing business. But I can't send staff to these things. And not every executive director can't, and throughout New England, can't go to these things. And so we tend not to be at the table. And then people wonder, why aren't you there? It's because we don't have the resources to be there. So, but these are really critical conversations. And when it comes to climate change and adaptation, of course, they're the inherent values of maintaining forest blocks and habitat connectivity, especially for the, as flora and fauna migrate because of the changing climate. But this is also critical work, and I think we've all become hyper aware of it, of the importance of conservation to help mitigate flood damage, to help mitigate drought, to help mitigate just numerous, it's just that fundamental green infrastructure that we are increasingly relying upon in order to continue to exist as a species. So I can't underscore, can't say enough about how important that work is, but it seems to be kind of often treated as a nice option if you can get around to it, as opposed to core work that we should be doing. So really long answer to your question, but that's the reality of actually doing that work around these constrained areas.
Okay, I guess I'm also just curious the process you go through to map them, and then how you work with your towns to help them build their town plan requirements.
It's really limited, again, because it depends on one hand, are the towns really looking at that? So we'll pull the information from the state. We all have professional GIS folk. We'll develop the base maps. We'll pull that information together. We'll let towns know that we've got that information, and to the extent that it's a priority of theirs, we'll work with them on doing it. We'll work with the planning commissions, conservation commissions. In our region, we partner closely with the Resource Conservation District. Land trusts reach out to us. Federal agencies reach out to us. But really, when it gets down to the town level, ultimately they drive their planning processes. We don't drive those. And it kind of depends on where they're at. So are they primarily focused on looking at their zoning for housing? Or are they looking actually at forest blocks and habitat connectors, and what can they do with their zoning around that to the extent that they have zoning? So I think the answer is we could do a lot more and be a lot more proactive if we actually had the staff resources to be out there and be proactive, but it tends to be more working with towns as they reach out to us and need help.
Yeah. So we did add another bill in at the end of the bill as introduce that includes staffing or
Right.
natural resource planner or a resilience planner or
Whatever, yeah,
be named, that could potentially fill that role.
great. And not pigeon, and to what you just said, not pigeonholing that role is increasingly important too, because like our natural resources work, you know, it's everything from culverts to habitat connectors. And that role in particular, hopefully through whatever performance-based contract would be in place, would not constrain that, because we really need to meet the towns where they are in these conversations. And every town is different, and increasingly, mercifully, a lot of our towns are realizing they really need to have more conversations among themselves, especially when it comes to river corridor and flooding. That they really need to have more cross-town conversations, and yeah, so that'd be great.
Representative Sibilia.
Thanks, Chris, for your testimony. I just want to make sure that I'm kind of following along here, that we are already mapping a lot of what would be included in tier 3 critical resource area. I think that's the chair's point. You and I are both from Windham County. Do you think that most Windham County residents are aware that we have been mapping that property for Act 250 jurisdiction?
Probably not, because I would say in general, most aren't aware of just necessarily what's required for permits or not anyway. So, I mean, as far as like, is the average Windham region resident saying, hey, they're mapping my land, they're probably where some state maps exist, but, and understand these constraints, they're, you know, the primary maps that we use are already the statewide maps. The bigger challenge, and like I'll use Marlboro as an example, we worked with them because they really wanted to drill down on like what stream corridors, what habitat connectors should they really be protecting in their zoning. And so when it comes down, especially to town regulation, where a lot of land use regulation happens, they certainly, the public becomes very aware of what the town is proposing. And that's really where that's a little different than just the higher level state mapping. Because as you drill down, and this is one of the things that I would love to be able to do more of, is really trying to prioritize where these critical habitat connectors are, because it's not necessarily every stream, every culvert crossing. There are ways that you can map to begin to have the conversation about, okay, this looks like a really key priority area where we could work with property owners in the towns in order to establish easements, permanent conservation easements, and then really work on like replacing that culvert to accommodate aquatic organism and terrestrial organism passage. You don't necessarily have to do that with all of them. You can prioritize where those are. And in our region in particular, especially the eastern part of it, is called, where we don't have a lot of large scale land holdings, that's really important. But the other key to this is oftentimes where those key corridors exist, those are also going to be areas that carry a lot of floodwater. And it's going to be really important to protect those rivers and streams, because as we see, the behavior is becoming much more unpredictable and violent. And so being able to better, and oftentimes as we protect the habitat connectors, we're also making sure that we protect those corridors where development could be frankly quite dangerous, both for the people who are immediately adjacent to those streams or rivers, and then of course the people downstream as whatever gets washed away goes down.
I guess, how many of your towns have done this mapping for an energy plan?
Oh.
And you can just, I mean, I'm just curious, half or most?
Ballpark, I think it's probably about 6, because it really gets to where they are in their own planning process. And generally speaking, they tend to be most motivated to do the enhanced energy planning when they think there's an energy project coming that they don't like. So, you know, the planning commissions, you know, they change membership every year, priorities change every year. The more recent priorities tend to be focused more around where do you develop housing, not as much on energy plans. But as they get through their 8-year, remember they're on an 8-year cycle, as they go through their, and they can certainly update their plans in between, but as they do that, that tends to be when they do their enhanced energy plan element. Generally, a lot of the ones that were really proactive were the ones where they were concerned about possible wind development or where they're concerned about very large scale solar development. And they themselves wanted to identify those preferred locations. And so it tends to be very kind of town demand driven.
Well, actually, I just want to follow up. We're not currently mapping for Act 250 jurisdiction, these resources.
Right.
Yeah, I'm aware of that, Madam Chair. I think that's what we're contemplating.
Okay, I
here
just
in
thought I
this
heard you say
proposal.
that.
And I've heard kind of reference that the mapping, we're kind of already doing this, like, it's not really that big of a deal. And, doing it for one reason and then coming in, and using those maps for something else feels like, there needs to be a kind of broad public discussion about that and engagement and explanation about the problem that we're trying to solve, how we're trying to solve it, what the accountability is as we're trying to solve it, what the engagement level is. And I don't think that work's been done. Would you disagree? Do you think that work's been done?
No, because we haven't been asked to do that yet. We do. Of course, you look at our future land use map, we already have resourced areas. I think it's called working rural lands area. We already mapped those because so to that extent, we've been doing that since Act 250 was created. And when we do that, we're also looking at town maps and of course the towns have the opportunity to veto our regional plan when we adopt it if they don't like it. And it really hasn't been an issue, but we already identify resource lands where we basically say development there is not appropriate. Oddly enough, we do have a carved out exemption for quarries, just because sometimes you can't have a quarry any place other than those. And there's a whole other area of testimony. There's a really fascinating relationship between climate change and a demand for gravel, sand, and everything else, because they're having to constantly rebuild the roads or do the repairs. And so the quarry is not all petering out quickly, but representability, yeah, we've been at a higher level mapping this stuff for decades.
So we actually need to move on to our next witness. Did you have one question? Representative Stone?
Yeah, really quickly. So you said that you found that the towns that seem to be doing sort of the energy planning work, it might have been out of motivation to try and, because a big project might have been coming.
Or had.
Or had. My question is related to that, like to the degree that you think the mapping exercise moving forward in this way could be used to, zone things out rather than, hey, this is where it would be great to have housing or whatnot.
Per our regional plan, generally speaking, the constrained areas already kind of line up with where we've identified, like what we call our resource areas. It's what you would call and more like those critical resource areas. They pretty much line up already. And of course, part of the process under the energy planning mapping is you're also doing overlays of like where the constrained lands. And because if you recall, part of the process of this was to identify how much energy we think we could generate and where. And so then you also have to overlay that, like, where do you have the best solar gain? Where do you have the best wind? Where do you have the best hydro opportunities? So that's constrained maps for kind of a base map for all these other things that you have to do. And I won't, because you need to stop, I'll just call your attention. I make some comments about the river corridor language. Just that I would just suggest you tie that in to other river corridor language already in statute, unless the intent is to make it broader than what's already anticipated. And there are a lot of different ways to get at it. Our position, I think it's fair to say for the RPCs, is generally speaking, the state really should take that on. Right now, it's optional for municipalities to regulate river corridors. But this is life safety. And really it needs to be regulated, period. And we would suggest a simple process like you would currently issue permits for wetlands or shorelands. But you could certainly put into resource lands and use the district commissions as like a screen, or they could issue the permits. Just But just be aware of that language and ultimately what the implications might be.
Thank you so much for your testimony. We have to move on. We have a lot of witnesses this afternoon. Sorry about that. We're going to welcome Liz Thompson via Zoom.
Madam Chair and members of the committee, I'm glad to be here. I'm Liz Thompson. Would you like me to go ahead and introduce myself, and then I will share my screen?
Sure, that'd be great.
Yeah, okay. So my name's Elizabeth Thompson. I live in Williston. I have been, I'm an independent ecologist. I've lived in Vermont since 1981. Retired from the Vermont Land Trust recently, but my career has involved work with the Nature Conservancy, Vermont Land Trust, and other entities. I was involved in the in the work on Vermont conservation design. Also, prior to that, Vermont Biodiversity Project, a previous conservation planning effort. An author of Wildlands in New England, which came out last year, co-author of Wetland, Woodland, Wildland, A Guide to the Natural Communities of Vermont. So I have participated a lot in conservation planning and in ecological work over the years. So what I would like to do, and I have to, just a second, I have to get the thing. Apologies for the technical. Is that visible?
Yes, it is.
Thank you. Okay, so I'm going to provide really some general, very, just really backing up and provide some very general background in my testimony and sort of where, in part, why this is so important. I'm really commend your efforts, really support the efforts to update Act 250. It's a landmark law that is certainly ready for updating. And I know you've been working on that for some time. I'm very excited to see these developments and new efforts to update this important law. So this is a really important time. So I'm coming to you partly as a representative of wildlands, woodlands, farmlands, and communities, which is a regional vision. So I'm going to just talk about how we fit in regionally to this work. And it's a regional vision for an integrated approach to conservation that includes wildlands, ecological reserve areas, woodlands, managed forest lands, farmlands, and communities. And one of the things that has come out of this wildlands, woodlands, farmlands, and communities is a good understanding of the history of New England. And this is just an example of a landscape in Massachusetts, in Western Massachusetts, what it looked like in the 1880s and what it looks like today. And Vermont is just like this, has had this same history. We can see in this graph the reduction in forest cover. New England was largely forested region 400 years ago and became largely deforested, and we're now at about 74% forest in Vermont. And with those changes came a lot of changes in wildlife, habitat. So you can see on the right-hand side of this graph, you can see that some wildlife species were almost extinct during the height of agricultural clearing and have returned now. So this is one of the key reasons that we need this forest fragmentation work. We need forest fragmentation to be addressed in Act 250. Another really important thing to see is the regional significance, actually the global significance of our forests. Our forests are some of the most intact forests, if you include all the Appalachians, some of the most intact forests in the world. And I believe that nationally and globally, we have a responsibility to keep our forests intact. But with this history, we are at a critical turning point right now, where this is our opportunity. We've got the forest back. Now is when we need to protect it. It is important for wildlife habitat. It is important, as others have talked about, for flood resilience, clean water, clean air, biological diversity. And this is just to show you that biological diversity increases with forest age. But what we're seeing here, of course, is what we've been talking about, the fragmentation, what you've heard from many other people about. We're looking at forest fragmentation, and this is what we really need to deal with. These are just 3 screenshots that I took last night as I was thinking about it. And these are 3 places that I know about, that I visited in my work around Vermont, places where, and I don't have the measurements as Jamie Fidel had earlier today, but these are roads that are upwards of a mile long, going deep into forest, and going to single homes. So this one is in Woodstock, and this road actually goes not only through forest, but also past many vernal pools, right through a couple of vernal pools. So really, really fragmenting the forest. And here's another one in that same area. This one here on the right-hand side is in Dorset, which is a place where this sort of thing happens. So I'm going to that's just a little bit of background. And, I know I don't need to say these things to you. I really don't. You've heard them all before and you are familiar with these, but I just can't emphasize enough the importance of addressing forest fragmentation now and through Act 250. Now, how that is done. So you asked me to address tiers 2 and tier 2 and tier 3, and my understanding, which is maybe there may be errors in my understanding, but what I understand is that the NRB report suggests a road rule of 2,000 feet, so that any development that involves 2,000 feet of road collectively would trigger tier 2, and that would trigger greater scrutiny for under Act 250, and that in the proposed bill H.687, you're talking. I use the term buffer, and that's not the term you use, but a 500 foot anything within 500 feet of a road would trigger review. Go ahead.
Outside of farther from the road, not within.
Yeah. Okay, thank you. So thanks for that clarification. I'm sorry. So I just wonder if personally, I wonder if some sort of combination of these things might work. And one of the things that concerns me quite a bit is that if there is a single road that's not a development, but that's going to a single house, that is a problem for me. And I heard from Jamie Fidel the possibility of an 800-foot rule for situations like that. So I think potentially some combination approach might work, but I do worry about the single road, the roads to single houses that aren't part of a development. As far as tier 3, those places that now my understanding is that these are described as critical resource areas in the proposed bill, and I believe you are talking about areas over 2,000 feet elevation, areas with shallow soils, steep slopes, important habitat connectors, and prime ag soils. These are, and then the NRB report, as I understand it, really just says that these need definition and mapping, and this would happen at the RPC level. My thoughts are that I actually think that A&R should lead the process, and you just heard about constraints at the RPC level, but I do think that A&R has the data They manage the data. They've been doing this for 40+ years, managing data on significant natural resources, critical resource areas. And they really, you know, they've done Vermont conservation design. They've thought about this stuff a lot. And I think Vermont conservation design should be used. It's not meant to be used as a regulatory tool, as you've heard, but the data contained within it is very useful and should be used as appropriate. Another thing that I just want to point out is that the data on these things are evolving. There's new data all the time, and new information is coming in. Now, potential features that could be included would be, as we have now, all lands above 2,500 feet. And in contrast to the suggestion that all lands above 2,000 feet should be included, I would maybe look at a subset of that to look at headwaters areas, areas with very shallow soils, as you indicate, and steep slopes. Not necessarily everything above 2,000 feet, because I think that's a lot, but look at really critical areas for flood resilience. Also, high priority connectors and certain forest blocks. But again, this is potentially a big one. This is potentially certain forest blocks. What do we mean by that? High priority forest blocks, potentially. What do we mean by that? Vermont Conservation Design has identified those, but again, if we used the highest priority forest blocks from Vermont Conservation Design, that's a large area. And my understanding is that the expectation is that these would be a relatively small percentage of the area of Vermont. So I think this is something really that needs to be worked out. Riparian areas and river corridors, if they are, I understand there's a desire not to be redundant with other regulatory mechanisms, but where they are not addressed elsewhere should be considered here. Wetlands also, as they are not addressed elsewhere. I understand the wetland rules are under review right now, may include riparian and river corridor protections. So I just don't know where that is in terms of other legislation and regulations. I think those things are in flux, so that needs to be addressed. RT&E species, rare, threatened, and endangered species, of course. Again, those things move. They're not necessarily always in the same place. Rare and uncommon natural communities and old forests. And here's the final one. I believe that we should be looking at potential old forests, which would be designated by an A&R-led process. And some of this work is ongoing, or is beginning or ongoing now. I also heard yesterday or the day before, I heard very clearly that the Agency of Natural Resources has limited capacity. The Agency of Natural Resources is at present deeply engaged in the really wonderful work of implementing Act 59. I've been involved in that, and that is really fabulous work, as John Austin said. So they have limited capacity. So I would really support the idea of adding capacity for this work to be done. And just to, I know you heard about Vermont Conservation Design from Eric Sorensen the other day, but there is the highest priority natural communities in dark blue, the highest priority landscape blocks. Look, that's a lot of Vermont. You're familiar with this. And in the blue, surface waters and riparian areas. So just to close, a few of the things that we know are important. This is the top of Mount Mansfield, place for a lot of rare species. This is a wetland in southeastern Vermont, and this is an old forest in southeastern Vermont, in the Vernon Black Gum Swamp. So I do think that these are features among the features we need to be looking at. So those are my comments, and I'll be happy to answer any questions if I can.
Thank you for your testimony. Yeah, I have a quick question. I think I would love to have you edify us a little bit you said, oh, well, where threatened endangered species might be moving. And part of what was on your list were rare and uncommon natural communities. As I know, you've long and wonderful career in being an ecologist in our state. How much overlap is between those two categories?
There is certainly some. There is some, and we often use natural communities as a surrogate or as a coarse filter for rare species, because many of the rare species also occur in rare and uncommon natural communities. Is that your question, Chair Sheldon?
That is, yes.
Yeah. So there is some overlap. And so there's a level of comfort that if we protect rare and significant natural communities, we'll protect a lot of rare species. There are some rare species, however, that don't occur, that occur in funny locations, like in power lines. And then there are species that move around, birds and other animals that move around from place to place and are not loyal to one particular natural community. So that's why there is a threatened and endangered species law, for example, that keeps track of those really vulnerable species.
Representative Sibilia.
Thanks for your testimony. Yesterday, we heard from the Agency of Natural Resources that Tier 3, as outlined in our bill, is closer to half of our land area, I believe, if I'm not mistaken. Would you concur with that assessment as outlined in the bill?
Well, what I heard them say and what I understand is it kind of depends upon how exactly they get described and designated. But potentially, as I showed you that map, if you included all, for example, all high priority in Vermont conservation design, all highest priority connectivity blocks, if that was a measure, that would include a lot of Vermont, a high percentage of Vermont. If you included all highest priority interior forest blocks, so we're getting into the weeds a little bit of Vermont conservation design, but yes, potentially, depending upon how you define it, it could include a lot of Vermont. And that's, that my understanding is that wasn't the intention. I don't, two thoughts on that. One, if places do rise to that level of significance, they are worthy of that kind of attention. Or another way of looking at it is, if it's really meant to be that those Tier 1 and Tier 3 are small percentages or small pieces of the landscape, and Tier 2 is all that, most of Vermont, as I read it, then some thinking needs to be done about how to define that, and that some of those features might best be treated in Tier 2. I don't know. It just depends on.
Liz, hi, thanks for coming. I think, as the chair mentioned yesterday, and I concur, there's not a logical connection in size between the 1A and 1B downtowns and critical natural resources area. There's no logical correlation between the two. And so I think, at least from my perspective, whether they are the same is irrelevant. What really matters is, how do we protect connectivity, and so if their highest priority under Vermont conservation design, and we were to be looking how to make it be less land, how would you actually do that if we've already said their highest priority, and without them we're going to lose critical habitat and connectivity? How do you how would we reconcile that with somehow making them smaller? Give a method for us, the way we might get there.
Yeah, I mean, there is. Thanks for the question, Representative Bongard. There is a a subset that about, that you've heard about, which is the staying connected linkage areas, which is a smaller footprint, if you will, or a smaller area of the state that is of areas that have been identified as really pinch points, very, very, like, already quite threatened pinch points. and there's a relatively small number of those areas. So that could be one way of really getting at, what are the most, I mean, they're all, so the problem is they're all critical, right? I mean, all of these connectivity areas are critical. But what are the ones that are Shutesville Hill Wildlife Corridor? There's one on Route 7 in Bennington Shasbury area. There's I-89 corridor. I mean, there's a few that are known real pinch points, and those might provide a way to really narrow down to the places that are like imminently critical, if not just plain critical.
That's helpful. Thank you.
Thank you so much for taking the time to testify with us again.
Thank you very much for having me.
Right. With that, we'll shift gears and welcome the Natural Resources Board up, and we're going to talk about governance in this next chapter of our journey through Act 250. Not sure, Sabina, do you want to join or who's coming?
I didn't know whether you were going to say after 5-minute break or something. Okay. Okay. Hello, everyone. Good afternoon, and thank you for the opportunity to speak with you again and provide feedback on H.687. For the record, I am Sabina Haskell, and I'm the chair of the Natural Resources Board. My comments today, as you said, are going to be focusing on the subject of NRB governance, which is central in both H.687 and our NRB study of recommendations, as well to the necessary updates to the program and general improvements in our organization's operations. Let me begin by saying that we all agree that the NRB will benefit from a professional board. It was a unanimous consensus point in our report, and it will be the starting point and backbone in taking the next steps that are outlined in H.687 and the NRB report. We agree that a professional board with part-time paid members and a full-time chair should have the qualifications and background that you laid out in H.687: environmental science, natural resources law and policy, land use planning, community planning, and environmental justice. And we agree that the board should be comprised of professionals from different counties to get a larger statewide perspective. Who and how the nominating committee is comprised can be straightforward. And I'll just step back for a second and say that I was a member of the Cannabis Control Nominating Committee and worked with Representatives Gannon, Representative Pearson, Ansel, and as well as Senator White and Anson Tebbetts. We were up and running and reviewing candidates and meeting regularly, and we put together a great interviewing process. And the long and short of it is we had consensus throughout the whole process on who we were all interested in, who we wanted to interview, what questions we thought should be asked, and eventually right down to who we all agreed on who got selected. No friction, no disagreements, and unanimous backing of the candidates. And that has been my experience in other hiring situations as well. At the NRB in the last year, we've hired 12 people. That's half our staff. We work together. We put together interviewing teams of different roles and responsibilities, and we all picked out the same candidates. And it just happens more than you. It's one of the most refreshing things about human nature is that you can agree on things like this. I would also like to say, I don't think that the executive branch member, one of the executive branch members needs to be from the Department of Human Resources. They are on call and ready to help whenever there are personnel policy questions or anything that has to do with hiring. I think it would be more helpful to include someone from one of the agencies that more routinely works with Act 250 and the NRB, because they'll understand what the right appropriate qualifications would be. And of course, that's up to the governor since it's the executive branch appointment. Where we do differ on governance is when it comes to appeals. I've already brought that up in previous testimony. I suggested it, if that is the goal, it should be postponed until the other necessary updates to the program are implemented and the board has had the opportunity to establish itself and its goals for the staff and the commissions and operations. I think hearing appeals at the outset is a little bit like putting the cart in front of the horse, and I apologize for putting it that way. But the implementation of the framework and properly defining that tiers will take time. Throughout the testimony that I've been monitoring, everybody, I mean, we all have a lot of input and ideas, and the board needs to put its attention to that first. And also to creating the oversight capabilities and guidance to the staff and the commissions. There's a lot of changes ahead of us. If the board's first duties are to transition to hearing appeals, it will create a firewall of sorts in the organization that will slow down everything else that you're trying to accomplish. I don't have a crystal ball, but I believe with the proper implementation of tiers of jurisdiction and instituting the review procedures for municipalities and future land use mapping, appeals won't be the issue. That won't be quite the issue. If the public and the applicants understand upfront where and how the process works, I believe there will be fewer appeals. And as Representative Baumgartz has put it before, proactive planning makes the process run better. And then circling back to something I have said before, I would request that H.687 refrain from over-defining and over-directing how the tiers will operate. I do think some sideboards may be appropriate, as in forest frag and habitat corridors. But how and what is in tier 3 is part of the mapping, the science, and the public engagement process. And it is intended to be a counterbalance to tier 1, not a sprawling regulation of the state that could affect the economic livelihood of our rural communities. I ask that the board and the RPCs and ACCD integrate and create the process first. Let these folks do the public outreach and the bottoms up planning that we back in our report and that so many people have talked about here and that you've expressed support for. And that will ultimately lead to a statewide consistent process that will make for the productive, proactive land use planning. So I've been asked a number of times by a lot of different people, so how would this time frame work? And I'd like to try to outline the steps here, but I'm going to be vague on dates because I know that Representative Baumgartz has the technical corrections bill in the Home Act that may or may not extend some of these, exemption dates and the sunsets of the exemptions. But the concept is that there should be a straight transition from the housing exemptions in last year's Home Act and those that may appear in H.719, the B Home Bill that is expected this year, so that there are no gaps in land use planning and Act 250 changes. Passing updates to the Act 250 law and passing housing legislation this year are not an either or in my book. It's a yes and. It's just as my experience with the Cannabis Control Nominating Board and our steering committee consensus work. We can find common ground and we can move forward on multiple complementary and parallel fronts. And I just want to take another second to address the concerns that have been raised a number of times that this will become an exemptions only bill and that the protections will be put off again. That is not the recommendation in the NRB report. Other witnesses have been very clear that this is a package proposal to be implemented together and in unison. And H.687 is clear on that as we are. It's not one or the other, it's both. So I want to just take a second and kind of walk through how we see 687 could be implemented. First, the board should be selected and seated. Next, it works with the designation and mapping teams, as well as other stakeholders to create the timeframes and the processes for the implementation. Meanwhile, the board will also be using this time to establish a new level of guidance and oversight of the NRB's operations and working with staff and commissions. Next, when the processes for implementation are ready, we come back to you, to the legislature, with plans for rulemaking or statute changes for the tiers, concepts, and locations, and how the certification process would work. After that, the new tiers program, and it's not exactly the right words, but I hope you're following me, rolls out the housing exemptions in last year's Home Act and the ones that might be included in this year's legislation would sunset, and the tiers oversight just takes over, if you will, with the appropriate outreach, training, and guidance that will be required. Another step, a year later, after all of this, the board would come back to the legislature and provide you with a status update report. How's the new framework working? How did it work the first year? What were the successes and the challenges? What was the data? What tweaks are needed? And then the board would undertake an in-depth review of the Act 250 updates, the duties and the responsibilities of the staff and the commissions and the board itself, what their role is, and adjust as needed, including whether or not they think they should hear appeals and come to you to get that authority. While we're discussing appeals, I want to share some data with you. We average 11 appeals a year over the last 6 years, from a low of 6 in 2021 and 13 last year. 13 last year included 6 appeals of JOs, 6 appeals of permits, and an appeal of a permit denial, 1 permit denial.
That's
Excuse me?
6 appeals of JOs.
I'm sorry, 6 appeals of JOs, 6 appeals of permits, and 1 appeal of a permit denial. We closed 15 cases in 2023 with an average time, okay, and this gets a little confusing, an average time of just over a year from when the applicant filed their application, 405 days actually. And then from the date of, and another way to look at it is from the date of appeal to the e-court was just over 6 months or 196 days. Are there outliers? Yes. Is that okay? Obviously not. But this is not unique to Act 250. There are outliers. This happens in municipal appeals and appeals of other permits inside and outside of Vermont. But there are outliers, as we all know. But I believe a professional board will be able to provide the supervisory oversight internally to eliminate most of the NRD-related time delays. And the new mapping and the tiers of jurisdiction should decrease the other regulatory delays. Before closing, I have a couple more thoughts about governance that were part of your legislative charge, and that's on staffing and fees. Just to recall, we have 25 permanent staff members and 3 limited service ARPA-funded positions through the end of 2025. One is the executive director, which you have called for in H.687 is making a permanent position. We agree, totally agree. We also ask that the 2 district coordinators be made permanent as well. The amount of work and the changes that are coming and the rewriting of guidance and the increased interaction with applicants that will be needed and with our municipalities and others of these changes is going to be significant. As well as we have right now identified over 400 ARPA projects that have come through with a grant process. Not all of them need Act 250, but we go through each one and make sure that we're giving them the pre-application information that they need and talking with the appropriate contacts. And there will also be some new responsibilities that will come with associated Tier 1A and B exemptions and how to make sure that they're being implemented responsibly and correctly. So all of this has budgetary consequences, and I can delve into that today, or I can come back at another time. But the bottom line is that, as you all know, our funding is derived 80% from fees and 20% from the general fund. And that exemptions that are in both H.687 and our report means a decrease in that fund, as well as, and then there will be additional costs associated with a professional board and adding these, if you move forward with that, adding the 3 positions. So we would like to say that if we want Act 250 to sustain our landscapes, we need to address sustainable funding to make that happen.
Thank you for your testimony.
Yeah. Any questions, comments?
Representative Smith has a
I
question.
do, thank you. You mentioned there was one appeal.
Of a denial?
Yeah, could you touch on that a little bit and tell me what it was about?
Was it Ernest? No. Yeah.
Actually, we ended up having one right at
At the
the end of
very
the
end.
year.
Oh.
Yeah.
Go, guys.
Yeah,
Yeah, so we did,
Pardon
so
me.
we did have,
for the record, maybe. you can-
Yes.
yeah, sorry, so Pete Gill, Executive Director, Natural Resources Board.
I goofed up
We
that.
did have, good question, we did have, one appeal of a permit, that was, and it was a denial of the permit because, it was an issue with the rhinos, the, irreplaceable, natural areas. And,
In Colchester.
yes, in cultures. And then we also had it gets a little bit complicated, but there was a, development for a kennel area that was, a denial based on Rule 34E, meaning that there was a previous permit on the property and it had specific conditions within it. And the commission found that those conditions shouldn't be changed for the proposed amendment for the operations there.
So does that become the end of the appeal process? Or is there an avenue that somebody can pursue that?
Right now, appeals go to the environmental court, the environmental division of Superior Court,
Okay, thanks.
And then the Supreme Court.
and then Supreme Court, which sometimes happens, as we know.
Representative Sibilia.
Is there any place I could see where the correlation between the appeals and the district?
Feeling I might get asked that. I do have that. So we had, I have it, the environmental court appeals filed last year by district. There were 2 in the Rutland County area, District 1. There were 4 in District 2, Wyndham and Southern Windsor. There were 2 in the District 3, which is Northern Windsor and parts of Orange. Well, all of Orange except for a couple of towns. District 4 had 2, which is Chittenden County. District 5, Washington County, where we are right now, had 1. District 6, Franklin and Grand Island had 1. District 7, the NEK had 1. 0 in Bennington County and 0 in Addison County. So they're all, they're all small numbers. That adds up to 13, but
Have that for other years as well.
I don't right now, but I can do that.
Yeah, I'd be interested in
Okay.
the last 5 years and
Okay.
noting that, though they're small numbers, they're huge costs with these appeals.
Yep.
Going through that whole process and I am not at all surprised to learn that the district that I am in has the highest number. So I will be curious to see if that is consistent across.
I will get that information for you. Yep. Sorry, I don't have that today.
Great, thanks for your testimony. We're going to take a 5-minute break.
Okay.
And if we are going to continue our testimony on H.687 and focus on governance and welcome Rob Willington via Zoom.
Good afternoon. Thank you. My name is Rob Wilmington. I live in North Bennington and I practice municipal land use, energy and environmental law in Vermont for 40 years. I retired last year. I've been involved in dozens of administrative and court proceedings involving Act 250, including many appeals to the Vermont Supreme Court. I've represented towns, regional planning commissions, interveners, and project proponents. I tried appeals before the old Environmental Board, as well as the Environmental Division of the Superior Court. My most recent Act 250 case in the Supreme Court resulted in the reversal of a shockingly bad decision by the Environmental Division relating to the siting of a commercial development at an interstate exit. I litigated dozens of zoning cases before local boards and in court in the Supreme Court, and I tried appeals before the former Water Resources Board. The appeals process in the Environmental Division for Act 250 has not worked in the way that many here hoped. It should be replaced, and I reached that conclusion for several reasons. First, I had extensive experience before both the old Environmental Board and the Environmental Division. The board did a much better job in processing appeals than the court. The board's decisions provided more guidance for the parties, and frankly, I found the process to be more streamlined. I tried big cases and minor cases in both forums, and the board did a much better job. That was my experience. Why did the board do a better job? Here are some likely factors. As with the Public Utilities Commission, the board has supervisory and regulatory oversight, as well as judicial responsibilities. And the board had a broader view than the court of emerging problems and recurrent issues in the administration of Act 250. In connection with thorny criteria like water, wildlife, habitat, and aesthetics, the board fashioned decisions that provided helpful guidance for developers, planners, and others in future cases. The legislature recognized this by statutorily requiring the environmental court to give precedential value to the board's decisions. The court's decisions have tended to resolve cases on narrow grounds and not provided comparable guidance. I saw many cases in which project opponents had valid, even compelling reasons to oppose development projects, particularly with commercial and industrial projects. Sometimes the flaws in a project are so severe that a permit is denied on appeal, but much more often project problems can be addressed by imposing permit conditions. The Environmental Board was not comprised solely of lawyers. There were engineers, former legislators, business people, planners. That blend of skill and experience can be very helpful in fashioning permit conditions that address real problems, but let a project go forward. A board with members of various backgrounds is likely to be more competent than an individual lawyer judge in fashioning appropriate permit conditions to mitigate impacts while still allowing a project to proceed. Also, there was more flexibility in getting administrative hearings scheduled because they only occasionally took place in courtrooms. Hearings could be and often were held in a variety of less formal venues and presumably were much easier to schedule. This is not a small matter. I was repeatedly told in court cases that scheduling a hearing would depend on the availability of courtroom and staff in a particular county, and we would often wait. I'd like to make two more quick points. First, many people are concerned about delays in resolving housing cases. You could require a board to give scheduling preference to any appeal involving a housing project of more than a specified number of units, say 10. Vermont law requires the Superior Court to give scheduling preference to cases involving claims of open meeting violations or public document requests. You could do something similar with certain housing appeals. You might also consider giving the board jurisdiction to hear appeals of agency permits if in fact those appeals have been unduly delaying resolution of housing projects. And I don't know whether they have or not, but that would be another function that the board could play. Second, a board could be empowered to designate a single member to act as a hearing officer in minor appeals, or to appoint a panel of 3 members to hear cases. This type of flexibility can speed along cases and tailor the administrative resources to the complexity of the issues. So in conclusion, I strongly recommend that the Environmental Division be stripped of jurisdiction over Act 250 appeals. All stakeholders, including developers, will be better served. It's time to restore a competent administrative body to do this important work, perhaps with panels or with the aid of hearing officers, as with the Public Utilities Commission. Thank you.
Thank you for your testimony. Representative Sibilia has a question.
Yes, thanks for your testimony. Can you give me a specific example of a decision in the last 3 years, 4 years, where we would have been better served by the appeals process that is envisioned in this bill?
Well, I referenced the case I mentioned before in the Superior Court involved a proceeding that was before it was in Woodstock. It was in the intersection of Route 4 there. It's before the District Commissioner Tim Taylor chaired. The District Commission did a really good job trying to address whether that site was appropriate for a big commercial development, and found in, I thought, very persuasive fact-finding and legal analysis that that it was an appropriate place for it. The commission did a really good job. The environmental court, well, they got reversed unanimously and decisively by the Supreme Court. They just misread the local plan, the regional plan. They applied the wrong criteria. It was a terrible decision. And I think the fact that the three lay panel did such a good job at track what the Supreme Court said was right, and the court got it wrong is one example.
Other members have questions? All right, thank you again for your testimony. Feel free to stay in the Zoom room if you would like.
I will for a while. Thank you very much.
All right, next up we have David Gregg. David.
I think he was
Is he on Zoom also?
Hi, good afternoon. My name is David Gregg, and I too am coming to you from North Bennington. I have started my career in 1990 in St. Johnsbury and was in private practice. I was lucky to be hired by former Environmental Board Chair Elizabeth Courtney in August of 1993. I was able to serve with a number of outstanding board members, including Ferdinand Bongartz, father of Representative Bongartz. I experienced firsthand the rejection by the Vermont Senate of Chair Courtney and members Bongartz and Terry Eric. It was a very disruptive period of time, and it really called into the question the independence of the Environmental Board. I was lucky to be general counsel of the Environmental Board when it was chaired by John Ewing. I believe that Chair Ewing, who of course I am grateful for having made me general counsel of the Act 250 program, he exemplified the qualities that you want in a chair if you're going to switch to the board model. He was an attorney, which meant that he was able to exercise independent legal judgment over the advice he received from me, fellow legal staff, and significantly the lawyers making arguments to the board. I want the committee to understand how important that was in establishing the credibility of the Act 250 program following the removal of the 3 board members by the state Senate. The perception had been that the Environmental Board was dominated by its staff. And while there was an element of truth to that, ultimately decisions are made by the board, not the staff. Chair Ewing had amazing business credentials. He was a lawyer. He was a former district commissioner chair, and he was able to exercise the skilled independent legal judgment that gave everyone the confidence that the decision ultimately was being made by the board and not the staff. In addition, the chair also needs to be someone who understands that their role is to be the program's defender. And what I mean by that is that through the course of my career, there has really been a nonstop criticism of the process. I think literally the only time I can remember people rushing to Act 250 to solve a new problem was when the burst of cell towers came on the scene. And Act 250's jurisdiction was hastily amended to recognize that this was going to be vertical development, not horizontal development. Other than that, there's been much criticism, much of which seems to repeat itself in cycles that I've experienced in my 30+ year career. The proposal to remove Act 250 jurisdiction and then with it potentially jurisdiction over appeals from the Agency of Natural Resources will bring you back to the state of affairs you had approximately 20 years ago. 20 years ago, approximately 20 years ago, Act 250 appeals went to the Environmental Board, and appeals from primarily the Department of Environmental Conservation would go to what was then the former Water Resources Board, and zoning appeals went to court. And the valid criticism was that there were too many forums and that your zoning appeal could go to Superior Court, your DEC permit could go to the Water Resources Board, your Act 250 permit could go to the Environmental Board. And the idea was to have a single fair fight. And what I mean by that is the overwhelming interest we have, I think, as day-to-day participants in the land use permitting process of Vermont, is we want the fair, consistent, and non-political application of standards. And to that end, I do not believe that what you have before you is going to strengthen the administration of Act 250. I fear instead that by separating jurisdiction among multiple forums, once again, there's going to be extended periods of delay where developers, neighbors, all participants find themselves engaged in protracted multiple forums where overlapping jurisdiction and subject matter is going to yield inconsistent and sometimes irreconcilable outcomes. Even if you had, on the one hand, zoning going to court and Act 250 and DEC permits going to the new board, you are inviting discrepancy between the two. And unless you're going to modify the Act 250 criteria, inevitably the same issues are going to be litigated in multiple places with the potential for inconsistent and irreconcilable outcomes. In turning to the idea of governance, I just want to highlight that I've heard this phrase, a citizen-friendly process, and my practice has been both citizen groups, neighbors, developers, municipalities. I don't know there are many people who can say that their past client roster includes the Nature Conservancy and Weyerhaeuser Timber Company, but I can make that claim. That has been the range of my client base. And it's always been because my goal is the consistent, fair, non-political application of legal standards to a set of facts. The idea that somehow the environmental court is deficient because it was reversed in a decision, to me, repeats the common practice where frustration with a particular decision maker leads to a reshuffling of the chairs. And I don't mean to be glib about it, but originally the Environmental Board actually had a provision which allowed for appeals to be removed to Superior Court. That provision was repealed many years ago, decades ago. As I said, there was a period of time after the removal of the board members by the Senate, where we wanted to have one fair fight. And key to that was the addition of appeal rights for all participants. That to me has been one of the most fundamental changes to Act 250 and which brought a sense of integrity and fairness to it. In other words, as originally enacted by the legislature, neighbors did not have appeal rights, and that skewed the process on appeal to the Environmental Board. I trust that if you move to this new board model, you will ensure that all parties have appeal rights. As for the nominating committee process, to me, it appears that you're trying to shift the control, the political control from the governor's office to the legislature, which if that's what you want to do, then that's what you're going to do. You've put two positions, you've created a committee of 6 representatives, which will be dominated by the legislature. I am a failure as a politician. I will never be a politician. I've been miserable at it. So I defer to you and your judgment, but I implore you that ultimately Act 250, Vermont environmental laws, zoning is hard. It's really hard. If you don't know how your ear is receiving the sound waves being generated by my voice, if you don't understand the technology and the interplay of electricity and sound pressure and calculus, then you're not equipped as a member of an Act 250 review board to make an assessment as to whether a project will have an undue adverse effect on aesthetics with respect to noise. That is just an easy example of many scientific, engineering, environmental science disciplines which regularly come before the land use review panels and boards. If I could make a plea, it would be for stability and investment in training and a recognition that it is difficult to get through Vermont's environmental laws. And if you want to make it easier, then repeal laws, lessen the number of standards, exempt development. I don't believe simply reshuffling the chair and separating out jurisdiction as this bill proposes will achieve the goal of what has been called a citizen-friendly process. Thank you very much for the opportunity to express my opinions.
Thanks for your testimony. You know, we've heard that one of the goals of going to the court was this idea of consolidated appeals, but then we've also seen data that indicates that they're very rarely consolidated. And I guess I'm curious, how many cases have you been involved with that are consolidated? And I guess I feel like you might have implied that the system we're proposing or looking at right now could lead to split decisions, but if you have examples of consolidated appeals and when the court takes them up, do they just say like, oh yeah, we support the NRB's decision and DEC's? Or I mean, I guess just because they're consolidated doesn't mean they're going to agree with all the permits that were issued under that case.
In fact, legally, the legislature has allowed them not to. It is provided for de novo review. So if your concern is that you don't like the court because it exercises independent legal judgment, then you would remove its de novo review authority and you would require that the court give deference to the decision maker below as to, or only review questions of law, but that the facts as found below, whether it be by the Department of Environmental Conservation, a local development review board, or the Act 250 Commission, would be binding on the court, and it would simply be limited to issues of law. That's the issue of how you get at deference or having the lower decision control. The other comment that you asked, or the question you asked me, was how many of my cases are, I say, consolidated. Judge Walsh and Judge Durkin would correct me. They would say they're coordinated, not consolidated, because what the goal has always been is to have a single evidentiary hearing for all permits on appeal. And 85% of my cases on appeal to the court involve multiple permits. It could be an Act 250 permit and a stormwater permit. It could be an Act 250 permit and a wastewater permit. It could be an Act 250 permit and a stormwater permit and a wastewater permit and a discharge permit and a wetlands permit and a zoning permit. So it is rare that municipalities have not adopted at least zoning. It is unfortunate that more municipalities have not realized that there is an incentive to have both zoning and subdivision, in that Act 250 jurisdictional thresholds rise when a municipality has both.
How much of your work is land use appeals?
100% exclusive. I only do environmental land use law. Like the only difference in my qualifications, as Attorney Wilmington described his qualifications, is that I'm a young kid. I've only been doing it for 34 years, not the 40 plus that he has.
Thank you again for your testimony.
Thank you very much. I appreciate it.
Next, we have Mark Hall.
Hi. Seems to be a bunch of us old land use lawyers wandering through your house looking for the committee room. Me being one of them. My name is Mark Hall. I'm with Paul Franken Collins. We're out of Burlington. I am the head of the Land Use Environmental Program. I've been involved with Act 250 and land use since 1991, when I first helped Dick Brooks fashion his initial chapters for his treatise on Act 250. After that, I was a federal law clerk, and then I went on to Paul Franken Collins, where I was mentored by Peter Collins in some of the larger, more contested Act 250 and zoning proceedings that have occurred in the state. The example being, I've been Costco's counsel since 2007. I was with Husky. I was with Walmart in St. Albans the first time around. I've been with Champlain Colleges in our master plan. So I've been around the block a few times. I come here because Austin Davis of the chamber said they're having a committee hearing. They may have some questions and you may be able to help out. So I'm here not representing anybody. I'm just here to see if you have any questions about my experience and what I think would help. My understanding, this is about the NRB and basically, how we want to structure. Some question as to what appellate bodies are the best. I've been here listening, and everything I heard from the board chairs, I agree with. And same with Mr. Gregg. I've known David for a long time. He hit everything on the head, and probably a better way, more eloquent way than I could say myself. My feeling is that there is a need for a professional board. Name of it, whatever you want to call it whatever you want. I think that the function of that board should be to work out the infrastructure and the overall regulatory structure of Act 250 and how it fits into or governs everything on top of the land use process in the state of Vermont. What I see in terms of my appeal problems is I see 10, largely 10, maybe 36, it depends how you count the subparts of permit conditions. Each one of them can be litigated, and each one of them is vague as you could imagine. The famous land use professor once said Act 250 was so vague that no one could really seriously think it's constitutional. When you have standards such as won't produce undue water pollution as a legal standard, means that all your decision-making regarding projects of any magnitude, whether it be a housing project or an industrial project, is based on an ad hoc process of litigating what these vague criteria means. And I don't think that's any way to run a land use program. So I would envision for the Act 250 people and the chair and his professional staff would be involved heavily in trying to thresh out those criteria and what really Vermont wants through a regulatory process, through rulemaking, also coordinating with the various agencies regarding what should be required. In that context, it also can help with its legal staff to support the commissions in a way that's not a conflict. You don't have lawyer that's representing the board hearing an appeal, that's also representing, giving advice to what a commission could be. I think the role of the board ideally would be as a witness in Act 250 proceedings before the court. Now, with regard to a board versus a court, I'm very adamantly in favor of courts. I've been in front of every board, and like the gentleman before me, I've been in front of pretty much everything that Vermont's ever had to offer relative to land use. I would say across the board that the court makes better decisions. I think their emphasis is on fairness. Their emphasis is on judging, which is to make decisions based on the law within the rules. My experience with boards very often is you do get commissioners or people who are coming into the thing with maybe a bit of a lean to them. And my view has been as that lean increases over time, and after a point, they are perhaps not hearing all the evidence being presented to them. They're only hearing what they want to hear. And they're often susceptible to hyperbole and evidence that, normal people look at, engineers otherwise are looking at it very askance, but it's ending up in the findings of the determinations. I'm a firm believer, judges, to become a judge in Vermont, a trial judge is very arduous. I mean, you have to have years of practice. You got to have support from your peers. You have to go through the committees. When you get to that age and you get to that experience where you're a judge, it's a fairly sophisticated animal. You're not going to just pluck somebody that has that experience and ability to make judgment off the street just because they happen to have an engineering degree or they have some degree from some college in planning or whatever. They're not going to have that ability to make decisions. They also make, as the one attorney pointed out, they make narrow decisions, and that they should be doing that. You don't want a decision maker based on applications out there making grandstanding type decisions based on some poor applicant's back. The courts will go out, they'll make a narrow decision. They'll avoid trying to make a decision they don't have to because they have a limited role. They're not there to establish themselves as a form of oligarchy that can dictate land use processes across the board through decision making. So in that regard, people have heard me say this. I call it the Harry Potter and the Sorcerer's Stone phenomenon. If you want the stone to have the power, you can't have it. And I think that's a very critical point when you're deciding who's going to be people making determinations on these contested appeals, especially if they're de novo. You don't want somebody making these decisions coming with, some preconception. And it concerns me because the process is getting set up, it seems to be, as David said, a political one in terms of who gets in these positions. And I think you're setting up a situation where you're going to maybe have undue influence relative to who's nominated, who gets appointed. I think if you go to the judiciary, you're going to something that's totally independent. That's my idea. Now, the question that you had earlier, how many appeals do I get involved with? I litigate pretty much 60%, 70% of my stuff is land use appeals. My appeals typically involve every permit they can friggin' appeal. So it's going to be a stormwater permit, it's going to be a wetlands permit, it's going to be an Act 250 permit, it's going to be a zoning permit. Pretty soon it's going to be 1111 permits. If there's error, it's going to be an error permit. It's whatever they can appeal, they're going to appeal. And if you're going to have peel off some or all of that from the environmental court to the board, you're going to double the cost for me, my clients. Obviously, you have the upfront cost to do the permitting. You got to meet the permitting. That's a whole different thing than spending 8 or 9 days or 15 days in hearings, in which each day of hearing, you got soft costs associated with engineers and architects and everybody else in the room where the fee is running at, easily could be $20,000 to $50,000 a day. And then you have to do it twice because you're in local zoning and in your Act 250. And it even gets doubly aggravating to the clients is that a lot of communities have adopted the Act 250 criteria within the course of the zoning permit. So you're going to be in court on the same criteria as you are in front of the board relative to what you're trying to prove for your permit if you split them. And I mean, I've heard people say that this multiple appeals in front of consolidated appeals, I call them consolidated despite the judge, is it's more the case for me that that happens than not. And I just, the idea of doubling and tripling that cost just makes no practical sense for me. I've yet to hear a reason why some sort of board be preferable to a court in these situations. So, I mean, if you want to ask me any questions, I think I've sort of scatterbrained made most of my points here. Is I think the system is fine as it is. It's just underfinanced. I mean, the judges don't. There's 2 judges deciding every decision in the state of Vermont relative from a zoning permit to enforcement action to an Act 250 appeal to everything else. And they have maybe 1 law clerk, and they each maybe 2 law clerks, and they're making all these decisions. If there's slowness in the system, it's because of that. But there's also ways the NRB could work to say, how do we consolidate the court system? Because there's a lot of discovery and other things, processes that apply in those appeals that don't necessarily have to. I could streamline the environmental court process, down to a 3 or 4 month process as opposed to a year. If you just look at it and say, what's necessary for the environmental court to hear?
Thank you for that. Representative Sibilia.
Thanks for your testimony. What additional capacity do we need in the courts for it to function more efficiently? Not, if, you could have every single wish, but, what would make a difference?
There's 2 things I think it could happen. First of all, is you could have, a couple more judges. And those judges could, to the extent their capacity is not being used, they are Superior Court judges, so they could help with the docket that exists in the various communities that is non-environmental. The other thing you could do is, I think you do need additional judges and law clerks, but I also think it would be helpful if the use of hearing officers, magistrates, things of that nature could do a lot to clear up what I consider the procedural issues as people bounce along toward the court. A lot of the court's time is spent deciding motions, deciding things that necessarily could be decided by somebody else that maybe isn't even full time. The thing is there's a lot of noise in litigation, and this is where I talk about you could streamline it a little bit. There's discovery issues, there's hearings, there's depositions, things like that could be curtailed quite a bit. But if there was a hearing officer that could sit up and deal with those things that keep the court away from deciding the larger issues, which are the decisions on the permit, I think it would be very helpful. An example would be in the federal court system, which I was involved with. They have a United States magistrate judge, and he oversees a lot of the procedures that take place in the larger cases. Some people say if it's larger than 2 inches, it goes to the magistrate judge, and he deals with all those preliminary issues. So the trial judge, the district court judge, can deal with the more critical trials and things like that. So you basically have a judge that just handles the paperwork, and then you have judges that decide the cases. Now, I think the PUC does that very often, these hearing officers, and that's very effective.
Can I just want to interrupt you because I'm sure our time is short here. If you were to add 1 more judge, which I think we heard testify to, what do you have any kind of specificity around the support staff that you would envision needing to be added alongside that?
I think in terms of getting decisions out the door, the primary thing is whether they have law clerks. Because the law clerks will be doing a lot of the first drafts of opinions, they'll be doing a lot of the research, and they would be advising the judge. And when the judge, by the time it gets to the judge, he's making decisions on stuff relative to this or that. But a lot of the time-consuming stuff, which is drafting, is done. Again, in this case, it's great for a judge because a judge rules, determines what ultimately happens, and he knows the law. The law clerk is just helping the judge. It's not turned around like David Gregg was talking about at the environmental board was for a number of years. You have a circumstance where if the judges have those support, they can turn out a lot more.
How many clerks does a judge usually have?
I think the trial court has one judge, one clerk. They may be at two at the environmental court per judge. I think it's one, but I'm not certain on that. I only see one in the last few times I've been in the courtroom. And what a law clerk judge is, a law clerk is typically fresh out of law school, usually with very good credentials in terms of grades, recommendations, who's, ready to hit the ground running. And they do a tremendous amount of work for the federal court. All the Supreme Court judges have clerks. All the trial court judges have clerks. They're a huge resource I'm a clerk, former clerk, we all raise our hands. I think that could help. But some form of off-lifting, if you can't just add 5 more judges, some way of off-lifting the burden on the judges to deal with stuff is just relatively trivial and could be done quickly by somebody else.
So I have a question. One of the reasons we're looking at shifting kind of back to the model is the idea that we hear a lot about inconsistency among the different districts and lack of oversight. So we're envisioning that a board that's actually engaged in kind of understanding land use decisions and providing oversight through this process will also be better positioned to promulgate rules and provide the sort of legal boundaries and guidance to staff. So,
I think that would be a primary role for a professional board to do so, but not in a judicial standpoint, but rather in an administrative standpoint, where they're making things consistent within their organization and making them flow, and then coming to you to ask for what they need, or going to the court when they have to say, Judge, we need consistency in policies, and this is what we've determined as being our position relative to what a criteria means or doesn't mean. I think if you put the NRB in a judicial standpoint, it really ties their hands behind their backs, because they have to avoid being in a position where they're conflicted.
thank you for that. Have you followed, there's a proposal in another committee to have a separate housing board of appeals.
I don't know how to say this, but the boards, to me, aren't as efficient or as good as the courts. And it's just, I just think there's enough boards. Another board and I get confused.
Thank you.
You got to explain this to somebody I explained, like, I do work for Costco, and I have to explain this to general counsel from Costco. And when I'm at about the 4th or 5th board, their heads are spinning, and it's, I think keeping them consolidated really helps.
Could probably talk all afternoon, but thank you for your testimony. Christopher Roy is next.
Afternoon, everybody. Thank you for the opportunity to speak on this. And I am well aware that being the last speaker on a Friday afternoon is a tenuous position. So
There's one more behind.
okay, good. Well, then I'll go on as long as I want.
The message.
So first of all, I'll let you know where I'm coming from. I'm with the law firm Downs Racklin Martin. I've been there for 34 years now, and chair the complex land use and development group. And that's part of the reason I'm here. But frankly, the other things that I've done along the way are more of a reason. Early on in the 90s, I served on the Burlington Planning Commission. And then the governor in the mid-2000s appointed me to the old environmental board that we've heard about. And I served on that board for 3 years. I subsequently was on the Williston Select Board for 8 years, and was then on the Chittenden County Regional Planning Commission, which I chaired before I stepped down recently. So I'm really coming at the issue of permitting in Vermont from a lot of different directions. The topic that we're speaking to right now is NRB governance, and I would like to focus on 2 things. The first of all, I think, is a consistent message that you've gotten, which I wholly support, going back to Chair Haskell's points. It is essential that the NRB be robust, be well-funded, and really have the tools at its disposal to do all that it can and should be doing, and which frankly it can't do right now, given resources, time, and the laws as they currently stand, especially given the dialogue in both chambers about changes to Act 250. There's going to be a lot on their plate. And I think it is essential that they get all of the resources they need, because in many respects, until the NRB is able to realize its full potential, I don't think we have an accurate picture as to what else truly needs to be repaired in any substantial way. One example being rulemaking. The NRB hasn't engaged in any meaningful rulemaking to speak of over the last decade plus. And as Mark mentioned, there's a lot about Act 250 that cries out for rulemaking. There's a lot of vague standards which are open to interpretation, which means that creates inevitably uncertainty, unpredictability, inconsistency. And the more the NRB had to devote to really creating a standards-based Act 250 process, I think it would be more efficient and it would be more effective. Another area which I think they could take a greater role on, frankly, is jurisdictional opinions could be handled by the NRB instead of the district coordinators. Right now, if you have a jurisdictional opinion, it's handed out to all of the district coordinators. And there is a real question of consistency under those circumstances. And ideally, the NRB is conferring with those coordinators and providing backup. But it may well be, in the interest of consistency, that jurisdictional opinions are another area where the NRB could have a more rigorous role. And then, as Mark mentioned as well, really being, once they have a handle on these things, then really being an advocate for the rules and policies that they've promulgated as sort of the guardians of the Act 250 program. And as Chair Haskell mentioned, even if one is supportive of having Act 250 appeals moved over to a board at some point, I don't know that now would be the time to do it. I think that it's an invitation for failure or dissatisfaction. The first thing would be really getting a handle on what sort of Act 250 2.0 is going to look like in a year or two, and giving the NRB the resources and the tools to really get that into shape, and then assess, are there ways to improve the appellate process? As was also mentioned, I think that a lot of that rulemaking, more resources alone would create a more timely, efficient, consistent appeal process, even through the courts. I was on the environmental board. I was very proud of the work we did on the environmental board. I think we wrote some fantastic decisions. I wrote a couple dissents that were particularly good. And at the end of the day, as good as that work was, I think Vermonters are better served by having all of those appeals go to courts. And the reason for that is, in the 70s, we didn't have the regulations that we have now. Frankly, we didn't have the engineering standards, the environmental standards, the consultants, the experts to do that sort of work on a number of things, be it environmental, noise, you name it. Now, more and more of that is really a matter of technical expertise, and taking that technical expertise and matching it up against the legal standard. And less of it has to do with sort of the soft discretion. And I think the farther we go down that path, the better off we are, because then both applicants and neighbors will know going into the process what the likely outcome is, and what areas maybe the project is deficient in or is going to be successful at. If more deference is desired for people making a non-legal sort of judgment call, then you could make whoever appeals an Act 250 decision have the burden of proof on the issue that they're appealing. So that is, if you lost below, you got the burden of proof now. And that would provide some level of deference to the non-court decision-making that took place on the local level. So if an applicant lost on an issue, they would have to prove their case on that issue to the court, vice versa. If the applicant prevailed, if an opponent appeals, then they would have to meet their burden of proof on appeal. My experience with the environmental court has been that, again, when given the tools and the resources, it's a more predictable, timely way of handling matters. Like the other lawyers you heard from, more appeals than not involve some level of consolidation or coordination. And the ones that don't are because the client says, well, tell you what, I know that my Act 250 appeal down the road is going to be in front of the same judge. So let's go forward with the zoning appeal now. And we know that there'll be some level of consistency when that Act 250 appeal comes up, second in queue, as opposed to doing it all at the same time. But it's an option that parties have in order to deal with things in an efficient way. It's at the end of the day, and I think the one thing, and frankly, I hadn't thought about it before. I'd thought about resources with the environmental division. I think having a magistrate, instead of, I know there's some concern about a third judge. It's like, oh my God, we're going to do a third, not a full judge, and it might even be a magistrate that's shared with another division. But to have a magistrate who can deal with some of the preliminary issues regarding discovery and other sort of procedural things that aren't really the meat and potatoes that the judge should be dealing with would really create a more efficient method. Likewise, more deadlines can be built into the system. Zoning right now, one well-known deadline is you have 40 days after a DRB closes its hearing before they have to issue a decision. And if they don't, it's deemed approved. And so, it's the old saying that a hangman's noose tends to concentrate one's attention. There's nothing like a deadline to make lawyers and their clients hop a little bit quicker. Ultimately, the Act 250 is such a tough nut to crack because it does so much. And it was brought into existence, 50 something years ago now, because of a desperate need to provide a regulatory context in Vermont for development that had very little controls. And it's important for all of us to realize, I didn't have gray hair when it was enacted. In fact, I was in kindergarten when it was enacted, and the world is different. And it is not a criticism or a failure of Act 250 to recognize that modernizing it is needed so that we're not, using a mimeograph machine when we should be sending things, over the internet. It's just a matter of updating it. And at the end of the day, I do believe a strong NRB with resources that can do the rulemaking, manage the program, and do all of those things well with professional members. If that makes sense, I think that would be fantastic. I think that's going to solve 75% of the issues. And then you can tweak the other 25% with some procedural and manpower things in the court. And I think you'd find almost all of the issues that people raise go away. I've tried. And your decision-making, and frankly, my testimony shouldn't be premised upon, how well I've done in front of the court, how well I did in front of boards and all of that. I've won some and lost some in every kind of forum there is in Vermont. And I've given the other hats that I've worn. And I saw Charlie Baker, walking around the halls here, and Charlie and I work very closely with each other. These issues are too important to get bogged down in the politics of the day. And I know that you folks wouldn't be biting off this, big piece to chew unless you had an interest in solving the problem. I thank you for trying to do so because it is a Sisyphean task. Hopefully the boulder doesn't roll down back on top of you. And I trust that at the end of the day, everybody's going to be able to work together to improve Act 250 in Vermont as a result. Happy to answer any questions you might have.
Yeah, thank you for your testimony. The boulder doesn't roll back to Representative Sibilia.
Let me add my support for the boulder not rolling back.
Yes.
I have two actually questions. One is on your contemplation about jurisdictional opinions, possibly going to the board. I have seen some pretty egregious violations, I think, around jurisdictional opinions. So on the face of it, I like the thought of that, but could you maybe provide the counter argument to why that wouldn't be a good idea? So why it's better to have JOs. And I'm going to ask you my second question now, which is around timelines.
Mhm.
I have proposed a 6-month deadline for completion of applications. I don't know if you've had a chance to see that language.
I've heard about it. I haven't read it specifically.
Well, if you've heard about it and if you have any thoughts about that, I'd appreciate hearing them.
So jurisdictional opinions are a sort of a funny little animal. It's always been with district coordinators, and actually back in the day, a district coordinator could ask him or herself to issue a jurisdictional opinion. And so there are stories of former district coordinators, if they didn't have much to do on an afternoon, driving around and seeing if there was some Act 250 jurisdictional question and then saying, hey, Jones, is there jurisdiction over that? Well, let me look into it, Jones. And then they would issue a jurisdictional opinion. And the Supreme Court ruled against that, and the legislature got rid of that practice. But it's always been before them. And part of that was because you then used to take an appeal to the environmental board. So it was a decision, but the coordinator would do it instead of the commission. So with the appeal now going, so you couldn't have the old environmental board do it because they were the appeal body. And this goes to part of the problem with having the board do appeals and also have to administer the program, because there's a certain amount of, you become judge, jury, and executioner all at once. And instead you want the board to have unfettered ability to support districts so that they can do the best work they can. But that's sort of a vestige of history. And I think, especially since in sort of an ideal model where all jurisdictional opinions are consistent, the legal staff is housed at the board. There already should be that dialogue. Is why not just have the board do that? And then the appeal would go to environmental court and that would frankly free up the district coordinators and the district commissions to process the applications in front of them in a more timely fashion. And then the body that has legal staff can do the work on the jurisdictional opinion, which are frequently fairly complicated matters. Regarding deadlines, I'm a big supporter of deadlines. Like I said, they make you tend to things. The difficulty will be you have to also constrain what you can do during those 6 months. Because right now, I can tell you without breaking a sweat, somebody who's appealing a decision. So the notice of appeal is filed, it's served on other parties. 21 days later, a statement of questions is filed. Within the next month, an initial pre-hearing conference is scheduled. At that point, they come up with a schedule for pre-hearing motions and a potential trial, usually 4 or 5 months down the road. Then parties can engage in discovery and there are no, for lawyers who practice in the area, there's sort of
It's a different deadline.
I'm talking about completeness of the application.
going back. Oh,
Termination.
I'm also that. So there are a couple deadlines right now before the district commission. Thank you for redirecting me there. That are in place. And one of them is from the moment the application is deemed complete, you have a certain amount of days to either have a pre-hearing conference or a hearing. And what has happened more and more often is you get the district coordinator without input from the district commission issuing multiple letters saying your application isn't complete. I need this, I need this, I need this. To the point where it starts to look like if you want to get a hearing, you have to persuade the district coordinator that you should get a permit. And that's not what is intended. An application is supposed to be sort of, here's the stuff regarding my elements. So you see this is a real project and we've done the work we need to do to satisfy it. And we will present all of it and more at the eventual hearing. So there needs to be a limit on the number of completion determinations. Then there is a deadline to get you to the pre-hearing conference. There should be a deadline from the pre-hearing conference to the hearing, because then what happens is you'll get a pre-hearing conference recess order, which says we need this stuff. And then you'll get a second recess order and a third recess order in some cases, not every case. I mean, these are sort of like the bad examples, right? A limit of one recess order that has to be issued within a particular period of time. Now, ultimately, the best way to do it might not be to do it all by statute, because that's a level of granular stuff that you guys don't usually get to. You may want to say, it's got to be done, that process 6 months, and you, NRB, promulgate the rules that get us there. But that's the statutory standard. And you folks who run the program know better than us how to get you to the incremental steps to get there. Again, if everybody goes into the process, it's kind of like if you were playing a board game. I mean, we've all had board games where there's a dispute among the family. It's like what the rules are. And that's like, where are we putting money in the middle of Monopoly or not, and blah, blah, blah. And that's where the disagreements happen. If everyone knows the rules, I think it's going to move a lot more efficiently.
We do need to go to our next witness. Okay, do you have a quick question?
I have a very easy question, Madam Chair.
Yeah.
If you had the intention of building a multi-million-dollar company and you wanted to start from scratch, would you build it in St. Johnsbury, Vermont, or Littleton, New Hampshire?
Well, I can speak from a permitting perspective. There's workforce and economic issues that are way beyond me. I could tell you that the permitting contingencies and unknowns would be a lot less on the other side of the river.
Thank you.
Thank you for your testimony. Right, committee, we have one more witness. It's Ron Shems. He's joining us via Zoom.
Good afternoon. Thank you for inviting me to testify. Greatly appreciate the opportunity to weigh in on the important issues that the committee's discussing. I want to thank Chair Sheldon, Representative Bongartz, and the committee for inviting me to testify today. I am a former chair of the Natural Resources Board. I'm not here on behalf of any client or constituency. I'm here to share my thoughts as a former chair, but also as a lawyer with experience in administrative law, and also as a lawyer who represents a lot of people going through the permitting process. Like David Drake, I represent some opponents, but the vast bulk of my practice is on behalf of developers, applicants for permits. Again, I'm not here on behalf of any of my clients, but my experience in representing applicants and developers is certainly shaping my testimony. I support H.687, and I can't overstate how important it is to address governance. Governance is critical to Act 250's efficient and common sense implementation, and it's also critical to containing costs. one of the issues that we haven't really discussed is, how are all these changes going to be implemented? The NRB is going to come up with plans and maps and all of that, but how is it going to be implemented down the road? And, currently the NRB has absolutely no authority over the program it ostensibly administers. We can use the JO example that was discussed earlier, which is if I ask a district coordinator for a jurisdictional opinion, they check a box or they actually write up jurisdictional opinion. And if the NRB disagrees with this core issue of how far does Act 250 jurisdiction extend, if they disagree with their own staff, they effectively have to sue their staff, or I have to take an appeal of that decision to the environmental court. We have to litigate this decision, and litigation is not it's an impediment to development. It's not an inducement. It's not a protection. Let me give you an example. And a couple of my clients I have one client that is a big commercial development in central Vermont that's the centerpiece of the new town center. Let's say a priority housing project is going to go into this, is going to be developed within this new town center. There would be no Act 250 jurisdiction based on the Home Act over this housing development. But what about the infrastructure, the road, the water, sewer going into the housing developments? How does that get resolved? Would Act 250 jurisdiction extend over the shared portion of the infrastructure, but not the portion of the infrastructure solely serving the housing? Would Act 250, would the exemption be limited to just the housing itself? We just don't know that. This bill may answer that question if it goes through, but in the meantime, that's not a question we want to have to go to court over. That going to court over a question like that would slow everything down. We want a prompt, common sense answer. And basically, to put it bluntly, it would be great to have a boss. Someone with authority over the program, someone who can provide an answer. And we don't have that right now. Like it or not, Act 250 decisions are made through a quasi-judicial process. That's how district commissions operate. And if the NRB or the ERB is going to have any authority over the Act 250 program, it too will have to exercise decision-making authority through a quasi-judicial process. That's just the way the system works because of how Act 250 has been set up. And so, after the plans are made, after the maps are set, how is this going to be implemented? For example, to use the example that Mark Hall had used, vague standards, undue adverse impact on water pollution or undue adverse impact on aesthetics. The environmental board came up with a Queechy test. That a court may not be able to do that. A court isn't going to be looking to implement housing policy. That's not a judicial function. That's an executive branch function. Developing tests and furtherance of a particular policy or a particular legislative mandate, that's something the ERB or NRB has to do. That's something that a court won't do. So you need a boss, you need somebody who's actually going to implement things, and then you can go to court, whether it's the environmental court or directly to the Supreme Court. That's a decision for you to make. I've got no qualms about the environmental. We need a decision to be made, and decisions to be made especially with these new changes, can't be made by a single district commission or a single district coordinator. They need to be made by the ERB or NRB. That's the only way the system's really going to work. And, if you're going to make big changes to Act 250 without having someone in charge of implementing these changes, that can undermine the changes. It could render them ineffective. It's a recipe for, a lot of litigation. Could lead to another to pick on Mark again, the Costco gas pumps situation, where there's just a lot of litigation to resolve stuff that could be set by rules, by decisions, by actually having an entity that can run the program. And so before we go to court, I would ask the committee to make sure there's actually somebody in charge, somebody with the authority to implement the change. I think there's a need to do that now. The example I just gave you, but there's certainly going to be an even greater need to do that down the road once these changes are ready to be implemented. Couple other notes, right now the composition of the ERB, I agree it should be a professional board. I certainly agree it should have all the tools and that it needs to have resources to be able to, exercise its authority in a robust way. But one of the tools that I'm saying is the authority to actually administer the program. Right now, the NRB does not have that authority. I very, very much agree with trying to insulate the ERB from any politics. And I would add even further that it should be, diverse from a political perspective. Transportation board, for example, it's a 9-member board, and the statute forming the transportation board says that there can't be more than 4 members of a single political party on that board. Diversity of political parties, as well as qualifications, and that could ease some of the concerns over ideology. Another thought is the de novo standard. Certainly know what de novo means. That's been the standard before the former environmental, for the environmental division. But there are also hybrid standards that could be more efficient that I'd urge take a quick look at. Also want to address rulemaking. That's been talked a lot about this afternoon. Rulemaking is critical, but in order to make a good rule, you need experience, and you need the experience gained from hands-on implementation of the program you administer. You can't make rules in a vacuum. And so I think, again, that compels having the ERB have actual and real authority over the program it administers. I think that fixing governance will lead to better economic growth. It's going to limit litigation, and it'll lead to much better implementation of the important changes that are contemplated in H.687. Finally, I wanted, I guess I'll touch base on consolidated appeals. I've handled many, many appeals to the environmental division.
So, Ron, we're having a little trouble with the sound, and now you've cut out, it seems, completely.
Oh, I'm sorry. Is this any better?
Probably. Let's try that.
In terms of consolidated appeals, I've been practicing for many years. I've handled many, many appeals to the environmental division. I've only had one case that was consolidated, and it's a great concept, but in practice, it doesn't really work, and it's rare to have it happen when it's coordinated or consolidated, because the timing of the various permits being issued and the 30 days you need to appeal the permits, they rarely coincide. It's not a neat process. So I talked fast and I bumped a lot of concepts, but happy to answer any questions.
Sure. I thank you for your testimony. I guess I'd like to follow up on and have you talk us through a little bit more, since you've had multiple, well, anyway, others have too, but so your idea that we need, I think there's agreement that we need a a professional board, and the question is the need for that board to hear appeals in order to have the experience to promulgate rules. Can you help us understand how that looks to you and why that matters?
50 is set up to make decisions through a quasi-judicial process. So if the ERB or NRB is to have authority over Act 250, it has to exercise that authority through that same quasi-judicial process. That's how the NRB or ERB would get hands-on experience with Act 250. And that, the actual administration of the program you're supposed to administer, actually doing it, that's what informs rulemaking. That's what gives you the experience to know this is what a rule should be shaped. This is what a rule could address. This is what a rule's limitations would be. Rulemaking is prospective only. It doesn't address things that come up. Things that come up get addressed through actual implementation of the program by hearing the appeals. The example I gave of how far would the exemption, with the priority housing exemption to Act 250 jurisdiction in a designated or in a new town center, how to actually implement that, that's not rulemaking wouldn't answer that question. It would be very, very fact specific. We would need the NRB to issue a JO on that. And to have to jump straight into court to get answers to kind of nuts and bolts questions is a step backwards in my mind.
Representative Bunger.
Excuse me?
Ron,
Another
be sure when you talk that you're closer to the computer because you're still breaking up. When you back up at all, you break up.
I tend to be soft-spoken, so please tell me to speak up.
Just to follow up a little bit, one of the advantages, at least that I've seen, thought about for having the board hear appeals is the shaping of policy. And you've alluded to this. In the past, we had the decisions that are still key to the process now in Quechee, Southview, and some others. And I guess, have we had, does the court provide anything similar in an ability to, because the board in the past and the way it might be envisioned under the rethought regime might be to, as the board hears these issues, it begins to shape policy that filters down through the system and then helps really provide guidance both to applicants, to everybody. And I just wanted you to, maybe comment on that. Are we getting the same kind of guidance in a way that is as potentially helpful as that might be, as we used to from the old system with the Southview, things like Southview and Quechee, and how important is that to the whole system?
Your an agency's ability to shape policy and actually implement policy is extremely limited if it doesn't have authority over the program. And Act 250 decisions are quasi-judicial in nature. RB would have to exercise authority over an appeal in order to do that. It would be applying facts to the program, to the requirements, shaping policy. That's absolutely critical. If the ERB were to not hear appeals, you'd be skipping that step. As a single district commission or a single coordinator isn't equipped to implement statewide policy. To the contrary, district commissions are meant to make sure that local sensibilities, the local flavor are taken into account, but nothing more. They're not charged with a statewide authority. They're not charged with a policy function, and actually administering the program, saying this is what the Act 250 permit should look like. These are what the conditions should be. That step is critical, and that has to be exercised by the entity that's in charge, the entity that administers the program. Then you can go to court, whether it's, you goes from the ERB to the environmental division, straight to the Supreme Court. You know, that's the policy decision for the committee to make, for the legislature to make. But unless the ERB hears those appeals, there'll be very little ability for it to, you're cutting out 50% of its ability to actually administer the program and shape the program. Does that answer your question, Representative Bonkarts?
Thanks for joining us and for your testimony. And thank you all for taking the time on a Friday afternoon to share your experience and perspective on this. It's very helpful. With that, committee, we will adjourn for the afternoon.